Hey everyone, welcome. If you've ever felt completely overwhelmed by legal jargon or honestly just wondered what exactly happens when those heavy wooden courtroom doors swing shut, you are absolutely in the right place. Today, we are demystifying the South African courtroom. From the outside looking in, court proceedings can seem unbelievably complex. Honestly, it's like they're speaking a totally different language, right? But underneath the wigs and the robes, the system actually follows a highly structured, step-by-step roadmap, and it's all designed for one very specific purpose: to ensure fairness. In this explainer, our goal is to break all that complexity down. We're going to map out exactly how the justice system works so you can navigate these concepts with total confidence.
Okay, let's dive right into this. Here is our agenda for today. First, we'll look at the broader roadmap to fairness, exploring the legal system's two main paths. After that, we're going to break down the 6 steps of criminal trials. Then we'll see exactly how private disputes are settled in civil trials. And finally, we'll wrap the whole thing up by decoding the language of law.
Section 1. The Roadmap to Fairness. To make things super simple, I want you to picture the legal system as a giant highway that hits a major fork in the road. Depending on the type of dispute, a case is going to travel down one of two very distinct paths.
Now here's that fundamental split. In criminal trials, you have the state actively prosecuting someone for a crime. Because someone's actual freedom is usually on the line here, the goal is proving guilt beyond a reasonable doubt. That is a seriously high bar to clear. In civil trials, on the other hand, you have two private parties disputing over things like money, property, or contracts. Because the stakes are financial rather than freedom, you only need to prove your case on a balance of probabilities. Basically, that just means your version of events is the most likely one to be true. Keep this massive contrast in mind as we explore each path.
Section 2, Criminal Trials, 6 Steps. So, now that we've got the big picture, let's head down that first path. We're going to unpack the 6 exact steps used to determine if an accused person is guilty beyond a reasonable doubt. Let's move to and see how this actually builds across a trial. It all kicks off with Step 1, the opening. This is where the prosecutor formally reads the charges and the accused enters a plea, either guilty or not guilty. Step 2 is the state's case. Now, because you are innocent until proven guilty in South Africa, the state literally has to go first. They call witnesses and try to prove guilt. Then we hit Step 3, the defense's case, which is the reply. The defense gets their turn to challenge the state's version of events. The accused can choose to testify, they can stay totally silent, or they can call their own witnesses. Step 4 brings us to the final pitch, closing arguments, where both sides summarize the evidence. Step 5 is the ultimate verdict, guilty or not guilty. And finally, Step 6, which only ever happens if the verdict is guilty, is sentencing. You can really see how this creates a structured back-and-forth rhythm between the prosecution and the defense, right?
Now, what's really interesting here, and you might have missed this if you watch a lot of flashy legal dramas on TV, notice what is completely absent from this process. There is no jury. No jury at all. Unlike in some other countries, South Africa just does not use a jury system. It is solely the presiding officer, so a judge or a magistrate, who sits there, weighs all the evidence presented, and delivers the final judgment.
If that judgment actually comes down as guilty, well, we hit that final step, sentencing. And the court doesn't just, pull a random punishment out of thin air. They hold an entirely separate phase just to weigh two competing elements. On one side, the defense presents mitigating factors. These are essentially reasons for the court to be lenient. On the other side, the state presents aggravating factors, reasons for the court to be really harsh. It's a very careful balancing act before the judge decides on the final punishment. That could be a fine, jail time, or maybe some other penalty.
Section 3, Civil Trials, Settling Disputes. Let's totally switch gears now and head down the other side of our roadmap. Remember, this is where private parties, a plaintiff who is suing, and a defendant who is being sued are trying to settle disputes based purely on that balance of probabilities.
Unlike criminal trials, which focus really heavily on physical witness testimony, civil disputes involve a literal mountain of paperwork. Months before anyone even sets foot in a courtroom, we have pleadings. This is where formal paperwork outlining the claims and the defenses is exchanged back and forth. Weeks before the trial is discovery, and this is absolutely crucial. It's a phase where every single piece of evidence must be shared between the parties. It is only after all of that extensive groundwork is laid that we finally reach the trial days. That's when evidence and cross-examination happen. And lastly, we arrive at the judgment on the final day, where the judge simply decides the winner.
And this brilliantly illustrates why real-life civil trials are so different from the movies. Think about the rule for discovery. Both sides are legally required to show each other all the documents, the photos, the emails, everything they intend to use. There are 0 surprise pieces of evidence allowed at trial. You literally cannot pull a dramatic smoking gun out of your briefcase at the 11th hour. Everything has to be transparently shared beforehand to ensure absolute fairness across the board.
So, what actually happens at the very end of a civil trial? Well, the judge's decision ultimately designates a winner and a loser, and either the plaintiff or the defendant could be in either spot. If you win the dispute, you usually receive damages, which is just legal speak for financial compensation, and importantly, you usually get a portion of your legal fees paid for. But if you lose the dispute, you're ordered to pay those damages, and the real sting in the tail here is that you are often required to pay the winner's legal fees on top of your own. It makes civil litigation a huge financial risk.
Section 4. The language of law. Okay, we've explored both paths now, criminal and civil, but to really navigate a South African courtroom like a pro, you absolutely need to know the lingo. Let's decode 3 essential terms.
First up, the presiding officer. Since there are no juries, as we discussed, this legal professional is the absolute boss of the room. But their specific title actually changes depending on which court you're standing in. In the lower courts, specifically the magistrates' courts, the presiding officer is called a magistrate. But if you step up to the higher courts, like the High Court, that exact same role is referred to as a judge.
Next, we've got cross-examination. You definitely saw this pop up in both the criminal and civil timelines. It's the act of an opposing lawyer questioning a witness. Basically, when one side brings a witness up to the stand to tell their story, the opposing side gets to test that story. They use cross-examination to poke holes, test truthfulness, or point out glaring inconsistencies. Honestly, it's one of the best tools the legal system has for getting to the real truth.
So the absolutely crucial point is this final term, the onus of proof. This simply means the burden of proving the case. Who actually has to do the heavy lifting to prove things? Well, that onus shifts depending on where we are on our roadmap. In criminal matters, the state carries the burden. They must prove guilt. The accused doesn't actually have to prove their innocence at all. In civil matters, the person doing the suing, the plaintiff, carries the onus to prove their claim.
Which leaves us with a really fascinating final thought to chew on. We've seen that the criminal path requires proof beyond a reasonable doubt, while the civil path only requires a balance of probabilities. So, does that difference actually change our whole definition of truth? Think about it. If something is highly probable in a civil court, it's considered true enough to cost you literally millions. But that exact same level of probability in a criminal court isn't true enough to send you to jail. It's a pretty powerful reminder that in the courtroom, truth is intricately tied to the path you're walking and the specific burden you have to bear. Thank you so much for joining me on this explainer today, and I really hope this roadmap helps you view the justice system with a whole new level of clarity.